In this video, I'm going to walk you through the 5 critical steps you need to take to build a strong defense and protect your company if your Florida LLC is ever served with a lawsuit. I'm Santiago Cueto, board-certified international business law expert and best-selling author, and I've helped thousands of Florida business owners defend their LLCs against every kind of lawsuit you can imagine. Instead of panicking, you're going to take control. When you're served with a lawsuit, your first instinct might be to panic, or worse, to toss the papers in a drawer and hope the problem just vanishes. But let me be clear, both are terrible mistakes. Lawsuits don't just go away, they get worse. Ignoring one is the fastest way to lose by default. So what exactly do you get when your LLC is sued? It's usually a package with 2 key documents, a summons and a complaint. The summons is a court's official notice telling you that you've been sued and have a limited time to respond. The complaint lays out who's suing you, why, and what they want, which is almost always money. When your most important job right now is to find out one specific piece of information, the deadline. Look at the summons. For most Florida state cases, your LLC has only 20 calendar days to file a formal response. In federal court, it's usually 21 days. This isn't a suggestion, it's a hard deadline. Now, if you miss it, the other side can ask for a default judgment. If the judge grants it, you automatically lose. They win everything they asked for without you ever getting to tell your side of the story. Now remember, filing a response isn't admitting you're guilty. It's exercising your right to defend yourself and forcing the plaintiff to actually prove their case. That clock is ticking, and you can't let it run out. Now, the second you know you're being sued, you have to look at your business differently. Everything, every email, text message, Slack chat, financial report, and voicemail is now potential evidence. Your second job is to make sure none of it disappears. This is what's called a legal hold. That means you need to immediately halt all routine document destruction. This includes auto-deleting emails, shredding old papers, or clearing out project folders. Send a clear written notice to your partners, key employees, and your IT department. It can be simple. Our company has been named in a lawsuit. Effective immediately, do not delete, destroy, or alter any documents or electronic data related to our business. This is a mandatory legal hold. Please confirm you've received this and understand. It's that simple. But why is it so important? Because intentionally or even accidentally destroying potential evidence is called spoliation, and Florida courts have zero tolerance for it. You could face heavy fines, or the judge could even instruct the jury to assume that whatever you deleted was bad for your case. Don't delete a single text. Don't clean up your files. Right now, that data is your armor. Don't throw it away. Now, once the shock wears off, you'll feel a powerful urge to defend yourself. You want to call the person suing you, fire off an angry email, or maybe even vent on social media. Don't do it. From this moment on, you need to adopt a vow of silence. Anything you say or write can and will be used against you. An angry email becomes Exhibit A for malice. A casual chat with an employee gets twisted in a deposition. A vague social media post gets shown to the jury to make you look bad. The only person you should discuss this lawsuit with is your lawyer, not your employees, not your friends, and not your family. If someone asks, the answer is simple and firm. Pursuant to my lawyer's advice, I can't discuss it. That isn't rude, it's smart. You're stopping the other side from getting ammunition straight from your own mouth. Now, these defense strategies I'm sharing could be the difference between protecting your business and losing everything. Now, if you're finding this valuable, take 2 seconds to hit that like button and subscribe to this channel. I break down critical legal issues for business owners every week, and you don't want to miss what could save your company. Let's keep it going. The next step is one that people overlook all the time, and it can be a financial game changer for you. You almost certainly have a business insurance, and one of those policies could be your lifeline right now. Pull out your insurance policies right away. You're looking for general liability, and if you have it, professional liability or E&O coverage. General liability often covers things like property damage or injury claims. Professional liability is for claims about mistakes or negligence in the services that you provide. But here's the most important part. Many of these policies don't just cover the final judgment. They cover the cost of your defense. Lawyers aren't cheap, and having your insurance carrier pay those fees can be the difference between surviving this and going bankrupt just from legal costs. Don't wait. Insurance policies have very strict rules about how quickly you have to notify them. If you wait too long, they might have grounds to deny your claims entirely. Find your policy, call your broker, and give them formal written notice of the lawsuit. This one phone call could literally save you thousands of dollars or save your business. Notice I didn't say you should hire a lawyer. For Florida LLC, you almost always must hire a lawyer. This isn't just strong advice, it's the law. In Florida, the law sees your LLC as a separate person from you. And just like you can't be a doctor for a family member, you as a non-lawyer can't be the lawyer for this other legal person, even if it's your own company. If you've tried to file court documents yourself, outside of some very small claim cases, the court will reject them. The outcome is exactly the same as if you'd done nothing, a default judgment, and that means you lose. So hiring an experienced Florida business litigation attorney is non-negotiable. They'll immediately file the right response to stop the default clock from ticking. They'll handle all communications with the other side, protecting you from saying the wrong thing, and they'll start building a legal strategy to protect your company's assets, and just as importantly, your personal assets. Your lawyer's first job is to fight the lawsuit. Their second job is to protect the very reason you created an LLC in the first place, the corporate veil. That's the legal shield separating business debts from your personal assets, your house, your car, your savings. The other side's ultimate goal is often to pierce the corporate veil so they can come after you personally. Now, a Florida court won't do this lightly, but they will if they believe your LLC is just a sham or your alter ego. This usually happens when business owners make a few classic, critical mistakes. Let me go through them. The first one is mixing money. Using the business account for personal stuff like groceries or a family vacation is the fastest way to break down that shield. The second one is skipping the formalities. If you don't have an operating agreement, don't keep business records, or don't document major company decisions, a court might see your LLC as just a hobby, not a real business. And third, committing fraud. If the LLC was used to mislead or defraud someone, a court will have no problem at all holding the owners personally responsible. And it's also critical to know Florida's specific rules for asset protection. For an LLC with more than one owner, Florida law offers a powerful defense called charging order protection. This means even if someone gets a personal judgment against you, they can't just raid the LLC's bank account. They can only get a charging order, which is like a lien on your share of any money the LLC distributes. If the LLC doesn't distribute any profits, that creditor gets zero. But a word of warning, these protections are much weaker for single-member LLCs in Florida. In some cases, a creditor might be able to foreclose on your ownership interests and essentially take control of the company to pay off a debt. A good lawyer will understand these differences and how to best position your LLC. All right, so let's recap the immediate battle plan. 1. Find that deadline on the summons. 2. Lock down all your data with a legal hold. And 3. Go completely silent with everyone but your lawyer. 4th, call your insurance company. And 5, hire an experienced Florida business attorney because you have to. That's the law in Florida. You can't and shouldn't navigate a lawsuit alone. The stakes are just too high. By following these first steps, you've already started to move from a place of panic to a position of control. A lawsuit probably feels like it'd be the end of your business, and I'm here to tell you it's not. It's a serious fight, but it's a fight you can manage. By taking these deliberate first steps, you're no longer just a target. You're an active defender of everything you've built. Your business is your vision, and it's worth fighting for. Now, if your Florida LLC is facing a lawsuit and you need expert guidance to build a powerful defense, don't try to navigate this alone. Click the link below to schedule a consultation with our firm, and make sure you like this video and subscribe to our channel for more critical legal strategies that protect business owners like you. I'll see you in the next one.